Welcome to Léargas' GDPR overview for beneficiaries. We all have a part to play in protecting our data and systems from unauthorised access or loss, especially when it relates to personal data. But what is your role as a beneficiary and what do you need to do? The purpose of this course is to provide you with an overview of GDPR legislation and your role as a beneficiary in relation to compliance with GDPR and Regulation 2018-1725. At the end of this course, you will know more about what GDPR is, understand how GDPR relates to you as a beneficiary, what you need to do if you receive a request for personal information, your responsibilities if you have a data breach, your compliance reporting requirements, and where to locate supporting resources and guidelines to assist you in your role as a data processor. The General Data Protection Regulation, or GDPR for short, is an EU regulation on data protection and privacy for all individuals within the European Union. The GDPR came into force across the European Union on the 25th of May 2018. GDPR forms the basis of our new Irish data protection laws, our Data Protection Acts 1988 through to 2018. GDPR and the DPA place legal responsibilities on Léargas and you as a beneficiary to protect any personally identifiable information that we may have. Regulation 2018-1725 is similar to the GDPR in that it has the same requirements to protect personal data and gives specific rights to the owner of the data. This regulation is specific to EU institutions and bodies that process personal data. As an EU body, the European Commission is required to comply with the regulation and ensure that any data processors on its behalf also comply with the regulation. In complying with GDPR and Irish Data Protection Act, you will be complying with Regulation 2018-1725. Personal information in this specific instance will relate to individuals and students whose data you hold and process on behalf of Léargas and the European Commission. If we do not comply with the GDPR or DPA in terms of the way we use and protect personal information, we could be subject to significant financial fines. It is therefore each of our responsibilities to ensure that we comply with the GDPR by abiding by the key GDPR principles and by adhering to the GDPR and data protection requirements noted in the beneficiary agreements. The aim of the GDPR is to protect the fundamental rights of individuals, in particular their personal data, and to define the legal framework for processing that data. To achieve this aim, Léargas is required to ensure that all processing of personal data adheres to the 6 key GDPR principles. And as a data processor of that data, it is your individual responsibility as a beneficiary to ensure that you take these principles into consideration when you collect, process, or keep personal data. The 6 key GDPR principles are that the data must be processed lawfully, fairly, and in a transparent manner in relation to the data subject. The data must be collected for a specified, explicit, and legitimate purpose only, and cannot be further processed in a manner that is incompatible with the purpose for which it was originally collected. The data must be adequate, relevant, and limited to what is strictly necessary in relation to the purpose for which the data was collected. This is often referred to as data minimization. The data must be accurate, taking every reasonable steps to ensure that the data is kept up to date. The data should only be kept for as long as is necessary for the purposes for which it was collected and processed. And finally, the data must be processed in a manner that ensures appropriate security of the data at all times, including protection against unauthorized or unlawful processing, and against accidental loss, destruction, or damage. The GDPR relates to all personal data. You will capture, process, and store personal data during the course of your role as a beneficiary. Some examples include contact details, names, addresses, emails, and phone numbers, bank details for the purposes of processing financial payments, course attendee and student data, including names, addresses, contact details, nationality, attendance on courses or at events, teacher data, including name, addresses, contact details, or attendance at courses, and supplier details in relation to the supporting evidence of expenditure, including name, address, contact details for the supplier. All of this data is classified as personally identifiable information under the GDPR and therefore must be collected, processed, and stored in line with the key principles of the GDPR. Some personal data you will capture and process for your own specific requirements. For example, when you capture and process your own employee information to facilitate the fulfillment of employment contracts and payroll obligations. In this instance, you are the data controller. A data controller is the person, authority, agency, or body that determines the purposes and means of the processing of the personal data. There are, however, occasions when we capture, process, or store personal data on behalf of another entity or organisation. For example, the EU Commission is the data controller for data collected and stored on the various Commission's online platforms. In this instance, you as a beneficiary are the data processor, as the EU Commission determines the purposes and means of the processing of the data. You will capture, process, and store personal data based on contractual obligations you have with Léargas and the Commission. Irrespective of being a data controller or a data processor, you as a beneficiary must always adhere to the 6 key principles of the GDPR. Under the GDPR, each individual has specific rights in relation to how their data is going to be collected and processed. These rights are the right to be informed. Prior to the collection of personal data, the data subject is entitled to be informed as to what data will be collected, for what purpose, and how it will be kept, along with other information in relation to the data controller, the data processor or processors, if there is more than one, and all locations of where their data will be stored, either in electronic or physical files. The right of access. Any individual whose personal data is processed may request information on their personal data. When they make such a request, the data must be provided to them within 1 month of receipt of the request. Right to rectification. In cases of incomplete, outdated, or incorrect personal data, the individual has the right to request that such data be corrected based on the provision of required documentation from the data subject. Right to erasure, or commonly referred to as the right to be forgotten. Personal data must be erased following an individual's deletion request unless any retention periods are set by applicable law or it is necessary to fulfill legitimate interest and contracts. Right to restriction of processing and right to object. Individuals have the right to demand the restriction of or to object to processing of their personal data if, in their opinion, the processing is unlawful, the data is no longer needed for the purposes of processing, or if the accuracy of the data is contested. Right to data portability. Where the processing of personal data is based on the individual's consent or was necessary for contract performance and is carried out by automated means, the affected individuals have the right to request a copy of their personal data in a common machine-readable format. Rights in relation to automated decision making and profiling. Individuals have the right to be informed of and have the opportunity to object to their data being processed in such a way as to include automated decisions or profiling of their data. As we have already noted, one of the key rights of the individual is the right of access to their data. Any individual whose personal data is processed by you as a beneficiary may request information on their personal data. If you receive a request for information from an individual that relates to the data you process on behalf of Léargas or the Commission, you must pass this request on to the Léargas Data Protection Coordinator immediately, who will assist you in actioning this request. As a beneficiary, you will be required to assist the data controller to complete the data subject request. The data controller may be Léargas or the Commission, depending on the data. If you receive a data subject request that is not related to information you process on behalf of Léargas or the Commission as your role as a beneficiary, you must follow your own internal GDPR policies and procedures to action the request. It is important to note that under the GDPR, all data subject access requests must be completed and the data sent to the individual within 1 month. You must not share any Léargas or Commission data with any third party without the express formal written approval of Léargas or the Commission. Under GDPR legislation, you as a beneficiary data processor must ensure that you have adequate security controls in place to protect the personal information that you are entrusted with. Samples of some of these controls include policies and procedures, formally documenting your organization's requirements on manual and technical controls to protect the data and the devices on which it is stored or processed. Awareness training for your employees in relation to the implementation of the security controls and processes. This would include not only training on your information security policy, but should also include phishing and social engineering training and how to recognize such attacks. And training should also include your GDPR and Data Protection Act policies and how your employees should comply with these. Technical controls that will assist you in the implementation of appropriate controls to protect the data. This could include, for example, antivirus software, disk encryption on laptops and desktops, the use of multi-factor authentication, for example, a code received on your phone in conjunction with your user ID and password to log in to your email or applications, or ensuring your patches are applied to your devices on a timely basis. Data backups, to have the ability to recover data and make it available in a timely manner in the event of a systems outage. Ongoing assurance of your security controls to determine if they are adequate and effective in keeping the data secure. It should be noted that these are just samples of security controls that you as a beneficiary should have in place. The data controller is responsible for defining how long data should be kept for. As the data controllers, the European Commission and Léargas will instruct beneficiaries on how long they should retain the data that they process on their behalf. You, as a beneficiary, should not delete information relating to the beneficiary process until provided with the guidelines and retention periods by either the Commission or Léargas. In relation to your own internal data, for which you are the data controller, you are responsible for defining the data retention periods and for ensuring that the data is securely erased once the retention period has been reached. As a beneficiary and data processor, you may be asked to provide evidence of the implementation of data retention instructions issued to you by the data controllers, i.e. the Commission or Léargas. Where a suspected data breach occurs relating to data that you process on behalf of the European Commission or Léargas, you must inform your Léargas Programme Manager and Data Protection Coordinator immediately. You will be required to assess the breach to determine if a breach has actually occurred, if personal data has been affected by the breach, the extent of the data affected, the impact on the data subjects affected by the breach, and if notification to the Data Protection Commission and/or the data subjects is required. Updates on the above will be required to be provided to the Commission and Léargas as your investigation progresses, along with the final outcome and formal report. So now we have covered GDPR and the key principles. How does this impact you as a beneficiary? On the following two slides, there are extracts from the various agreements that you as a beneficiary will be required to sign and comply with. These agreements contain specific requirements relating to Regulation 2018-1725, which, as we have noted earlier, is similar to GDPR. Do not be too overwhelmed by the volume of wording on this slide, as the wording is an exact extract from your beneficiary general conditions, so you will have copies of it available to you. As noted in the text, the key issues are compliance with Regulation 2018-1725, GDPR and Irish Data Protection Acts. Restrict access to personal data and ensure that there are confidentiality and non-disclosure agreements in place for any individual that you give access to the data. Ensure that there are appropriate and effective security controls in place to protect the data from disclosure, modification and non-availability. And finally, conduct regular tests to confirm that the controls in place are adequate and effective, all of which have been covered in the previous slides. Again, do not be too overwhelmed by the volume of wording on this slide, as the wording is an exact extract from your beneficiary grant agreement's special conditions, so you will have copies of it available to you. As you will note, you as a beneficiary will be required to include in your final report the measures and controls you have put in place to ensure compliance with Regulation 2018-1725. In addition, as a beneficiary, it is your responsibility to ensure that you provide all participants with a privacy statement in relation to the processing of their personal data. This privacy statement must be clear and easy to understand by your participants. For further information on GDPR, Data Protection Acts and Regulation 2018-1725, you can access and search these websites. The Irish Data Protection Commissioner's website, www.dataprotection.ie, the UK's Information Commissioner's Office website, www.ico.org.uk, and the European Commission's website, commission.europa.eu.